Hello friends, in this video we will discuss about what is a public issue and in which circumstances a company cannot issue its securities to the public. In particular, objectives of today's class are to know which companies are ineligible for bringing initial public offer IPO and to know which companies are ineligible for bringing further public offer FPO. Let's first see what is a public issue. Public issue means issue of securities to the public. It can be either initial public offer or further public offer. A public issue is said to be initial public offer when an issuer issues securities for the first time to public, and any subsequent issues of securities to the public is said to be further public offer. Further, both IPO as well as FPO can be of two types. These can be either fresh issues of securities or offer for sale. Fresh issue of securities means additional capital is being raised by the issuer. For example, if paid up capital of an issuer is rupees 5 crore and issuer needs additional funds of rupees 5 crore, then it can issue fresh securities of rupees 5 crore to raise additional funds. Offer for sale means securities held by the existing shareholders are being offered to the public by the issuer. The shareholders whose securities are being offered to the public are known as selling shareholders. These selling shareholders may be promoters or may be non-promoters. This happens when existing shareholders want to disinvest in the company. In the case of offer for sale, no additional capital is being raised by the company. Only shareholders of the company get changed after the entire issue. Now let's see the ineligibility criteria for issue of securities to the public. If we talk about the entities who are ineligible for bringing initial public offer, then Regulation 5 of Sebi, ICDR regulations talk about the criteria under which a company cannot come up with an IPO. This regulation lays down 5 situations when an entity will not be eligible for bringing initial public offer. We will discuss about these 5 situations later in this video. If we talk about the entities who are ineligible for bringing further public offer, then Regulation 102 of Sebi, ICDR, regulations talk about the criteria under which a company cannot bring further issue of securities to the public. This regulation lays down 4 situations when an entity will be eligible for coming up with further public offer. But there are 4 situations common in both the cases. That means the 4 situations given under Regulation 102 are the same as the first 4 situations given in Regulation 5. Now we will see all these situations. But before we discuss all these situations defined under respective Sebi regulations, we need to know the meaning of 3 important terms, which are debarment, willful defaulter, and fugitive offender. Let's look at the meaning of debarment. Debarment means an order which prohibits an entity or a person from accessing capital market. The person who is prohibited can not access capital market either as an issuer or as an intermediary or as an investor or in any other manner. To debar somebody from accessing capital markets, Sebi has the authority and requisite power. Now let us see the meaning of willful defaulter. Willful defaulter is a term used for borrowers who avail a fund-based or non-fund-based facility from the bank. A borrower is said to be a willful defaulter when borrower has capacity to repay but does not repay the loan to lender, or borrower diverts or misutilizes the funds borrowed by him. If these conditions are met, then lending bank or financial institution may declare the borrower to be willful defaulter. Now let us see the meaning of fugitive offender. In simple words, fugitive offender means fraudster, but the word fraudster doesn't look good. So we have given it a fancy name, fugitive offender. A fugitive offender is a person who commits a specific crime involving money of rupees 100 crore or more and absconds from India or refuses to come back to India. Special courts have the power to declare a person to be fugitive offender. For your general knowledge, let me tell you that first fugitive offender of our country was Vijay Mallya and second fugitive offender was Nirav Modi. So now, as we know the meaning of all the three terms, we can move ahead and see all the 5 situations when a company is ineligible for public issue. We will see first 2 situations when we will do a small exercise, and then we will see the remaining 3 situations. First situation says that when an issuer itself or the director of the issuer or the promoter of the issuer or the selling shareholder of the issuer are debarred by Sebi from accessing the capital market, then the issuer cannot issue the securities to the public. Second situation says that when any company other than issuer is debarred by Sebi from accessing the capital market, and either any of the directors of the issuer or any of the promoters of the issuer is associated with the debarred company as the director or the promoter of the debarred company, then issuer cannot issue its securities to the public. To understand these 2 conditions better, let's do a small exercise. In this exercise, I'll tell you who is debarred by Sebi from accessing the capital market, and you have to tell me whether Reliance Industries, who is the proposed issuer of the securities to the public, is eligible for the public issue or not. First, if Sebi debars Reliance Industries itself from accessing the capital market, then you tell me whether the Reliance Industries can bring the public issue or not. The answer is no. You can see the reason in the brackets on the screen. The reason is because the issuer itself is debarred from accessing the capital market. Next, if Sebi debars Nita Ambani, who is the director of Reliance Industries, then tell me whether Reliance Industries can issue its securities to the public or not. The answer is no. This time because the director of the issuer is debarred from accessing the capital market. Next, if Sebi debars Mukesh Ambani, who is the promoter of Reliance Industries, then tell me whether Reliance Industries can issue its securities to the public or not. The answer is again no. This time because the promoter of the issuer is debarred from accessing the capital market. Next, if Sebi debars Reliance Capital Limited, whose one of the promoters is Nita Ambani. This is the same Nita Ambani who is the director of Reliance Industries. Now tell me whether Reliance Industries can issue its securities to the public or not. This time also the answer is no, because one director of proposed issuer Reliance Industries is associated with the debarred company as a promoter. Next, if Sebi debars Reliance Communications Limited, whose one of the directors is Mukesh Ambani, this is the same Mukesh Ambani who is the promoter of Reliance Industries. Now tell me whether Reliance Industries can issue securities to the public or not. This is similar to previous situation. This time also the answer is no, because one of the promoters of the proposed issuer Reliance Industries is associated with the debarred company as a director. Next, suppose the proposed issue is the case of offer for sale where securities held by existing shareholders are being offered to the public. Now if Sebi debars Rakesh Jhunjhunwala, who is one of the selling shareholders, then tell me whether Reliance Industries can issue securities to the public or not. The answer is no, because one of the selling shareholders has been debarred by Sebi. Now suppose in all the cases which we have just seen, what will happen if I say the debarment period is over? Will Reliance Industries still be ineligible for bringing public issue? This time our answer will change, as that this time Reliance Industries will not be ineligible for public issue. With this, our exercise is complete. So till now we have seen two situations for ineligibility. Now we will see the rest of three situations. Third situation says, if any of the director of the issuer or any of the promoter of the issuer are fugitive offender, then the issuer will be ineligible for public issue. Fourth situation says that if the issuer or any of the director of the issuer or any of the promoter of the issuer are willful defaulter, then the issuer will be ineligible for public issue. And finally, fifth situation says that if an issuer has issued convertible securities and such securities are outstanding, then the issuer will not be eligible for public issue. However, this condition has two exceptions. First exception is that when an issuer has issued convertible securities to its employees as per ESOP scheme, then issuer will not be ineligible. And second exception is that when an issuer has issued convertible securities which are required to be converted before the date of filing of prospectus with Sebi, then issuer will not be ineligible, because in this case effectively company does not have any convertible securities outstanding at the time of bringing public issues. So there were the total 5 situations where a company cannot issue its securities. All these 5 situations are given under regulation 5 of Sebi, ICDR regulations, and disqualifies any issuer from IPO. However, only initial 4 situations are given under regulation 102 of Sebi, ICDR regulations, which disqualifies any issuer from FPO. So situation number 5 is the only applicable in case of IPO and not for further public offer. So in this video we have seen what is a public issue and under what circumstances a company is ineligible for bringing public issue. In upcoming videos we will see new developments. Till then, goodbye. Thank you.